Hello everyone, I'm Debojeet here to welcome you to another episode of Courts Today by LiveLaw, the one place you need to check in for your daily legal roundup of the top legal headlines. Today was a busy day, so let's get right into it. We usually start with the Supreme Court, but today an interesting hearing took place that requires your immediate attention. Following the controversial public statements by ex-CJI D.Y. Chandrachud regarding the 2019 Ayodhya verdict, lawyer Mehmood Pracha took an anticipated legal step by filing a petition in a Delhi court seeking to set aside the judgment alleging fraud. Pracha's central claim was that the judgment was vitiated because the former Chief Justice of India had publicly admitted to praying to the deity for help, which Pracha argued constituted unlawful interference. The judiciary's response was severe. District Judge Dharmendra Rana not only dismissed Pracha's appeal but heavily penalized him, increasing the original fine from 1 lakh rupees to a total cost of 6 lakh rupees for filing a frivolous and luxurious litigation. The judge concluded that Pracha had missed the subtle distinction between the supreme god and the juristic personality of the deity in court, asserting that seeking guidance from the Almighty cannot be condemned as a fraudulent act in law or religion. Now, starting with the top court, in a highly significant development in what represents the crisis of civil liberties in India, the Supreme Court refused to delay the process any further regarding the bail pleas of activists like Umar Khalid and Sharjeel Imam in the Delhi riots conspiracy case. The core of the matter is the stunning delay. These petitioners charged under the draconian UAPA or Unlawful Activities Prevention Act have been behind bars for over 5 years now, and the trial itself is nowhere near completion. It has been said a lot, but never enough. This isn't justice, it's punishment by process. When the Delhi police sought more time to file an affidavit, the bench of Justices Arvind Kumar and N.V. Anjaria was not having it. Justice Kumar asked pointedly, "We have given you enough time. 5 years have completed." In plain terms, the Supreme Court urged the prosecution to consider speeding up their process in this half-a-decade-long matter. The judiciary is now essentially asking the executive to clean up its own mess, highlighting the severe damage being done to the fundamental right to a speedy trial. Next, we take a look at another display of systematic blockage of democratic institutions in a frustrating saga playing out in the Supreme Court over the functioning of India's transparency watchdog, that is, the Central Information Commission. Activist Anjali Bharadwaj and advocate Prashant Bhushan are fighting a losing battle against the government's quiet attempt to kill the Right to Information Act. Their argument is simple. The government is intentionally dragging its feet on filling vacancies and is refusing to disclose the names of shortlisted candidates before appointments. Bhushan bluntly calls this out as allowing the government to airdrop favored individuals, even journalists who praise the regime with no relevant experience, all the while killing the RTI Act by making the CIC or the Central Information Commission effectively defunct. The Supreme Court unfortunately gave the government a huge benefit of the doubt. Despite acknowledging the delay, the bench refused to mandate the pre-appointment disclosure of names. Justice Suryakant stated, perhaps a little optimistically, that there was no reason to doubt the union would be transparent, and assured them that the appointments would happen soon. In a sense, the judiciary has chosen to trust the executive's promise over enforcing the immediate transparency required for a strong democracy. As Bhushan concluded, no government wants transparency. Moving on to what was a severe and frustrated reprimand over the continuing stray dog crisis, the Supreme Court summoned the chief secretaries of nearly all states and union territories for failing to comply with its orders on implementing the Animal Birth Control or ABC rules. The bench of Justices Vikram Nath, Sandeep Mehta and N.V. Anjaria expressed deep dissatisfaction, noting that despite an August order being widely publicized, only West Bengal, Telangana and the Municipal Corporation of Delhi had filed compliance affidavits. Justice Nath sharply criticized the officials' non-compliance, asking, "Your officers don't read newspapers or social media? Everyone has reported this." He added a stern warning that continuous inaction on the issue was allowing continuous incidents to happen, severely damaging the image of the country in the eyes of foreign nations. The defaulting secretaries were warned that they must now personally appear to explain their inaction. Next, digital arrest scams, where scammers use fake court orders and pretend to be judges or police to trick people into spending money. It is being taken as a serious threat by the Supreme Court now. The bench of Justice Suryakant and Justice Joy Malia Bagchi actually took up the case suo motu after getting a letter from an elderly victim. They realized this isn't just a local petty crime. Justice Suryakant stressed that these scams are operating pan-India or even across the border. Their proposed solution is huge. hand over all related cases from every state and union territory to the CBI. Why? Because the crime is now considered to be international. The Attorney General confirmed the money laundering networks are based outside India, even naming places like Myanmar and Thailand. Even more disturbingly, the Solicitor General explained the human cost. Victims are sometimes lured abroad and essentially turned into human slaves, forced to generate scam funds online. The court knows that local police cannot handle a racket this sophisticated and borderless, and they are now checking to make sure that the CBI has the muscle to fight this massive international cybercrime threat. Now we move on to a troubling development from Guwahati. The fact of the matter is this. A prominent journalist, Abhisar Sharma, was charged by Assam police with offences related to endangering national sovereignty and promoting enmity, serious national security issues, all because he criticized the Chief Minister, Himanta Biswa. The journalist's crime was suggesting that the Chief Minister was pursuing communal politics, that the government survives only on Hindu-Muslim polarization. As a concerned citizen, you must ask yourself, how can such an opinion conceivably pose a threat to the sovereignty of the nation? The police action here is a textbook example of equating political criticism with anti-national activity. Fortunately, the Guwahati High Court has been a check on this overreach, repeatedly extending Sharma's interim protection. Crucially, the state's own inability to even produce the case diary underscores the weakness of the prosecution's case. Ultimately, this episode warns that a democracy where you cannot say out loud what you see is a democracy where you'll eventually have to do what you're being told. Next, we take a look at the Kerala High Court's bench of Justice Devan Ramchandran and Justice M.B. Snehalata, which issued a stinging rebuke over the outrageous conduct of a litigant claiming to be an advocate expressing shock and petrification. The controversy peaked when the woman challenging her divorce decree refused a directive to remove her professional gown, a requirement for self-representation in a court, and made an obnoxious and perverse statement suggesting the judges were denying her a hearing in robes because they want her body to be exposed. The judges recorded that she also spoke intemperately, leveling accusations that they were undeserving and lacked knowledge of the law. Furthermore, her legal submissions were considered to be self-contradictory. She claimed to be mentally sound, yet argued that divorce decree was invalid because she was allegedly insane at the time it was passed. While the court dismissed her plea and refrained from contempt proceedings, it sharply questioned her credentials, stating if she really is an advocate, we find it alarming for the profession. And before we call it a day, an important notification from the Consortium of National Law Universities that has finally set up a high-powered expert committee to recommend sweeping reforms for the Common Law Admission Test or CLAT, both for undergraduate and postgraduate examinations. Their mission is to conduct a comprehensive review of the CLAT's quality, question design, structure, and academic relevance. Crucially, they want to hear from you. They've opened up the process for public suggestions and feedback. The deadline to submit your inputs is November 4th. Whatever reforms they propose will be implemented starting with the CLAT 2027 exam. That's all from our side for Courts Today. Remember to access every story, order, and judgment mentioned here. Visit www.livelaw.in and follow all our socials to stay updated with everything that is law. I'm Debojeet Das. Thank you for watching.